And welcome once again to Employment Hour in 30. I am John Scholes. He is Lior Samfiru from the Samfiru Tumarkin law firm. We talk about your job on this show and everything, how important that is, 8 hours a day. Generally, you probably spend at the workplace. So this is a show about workplace rights and what you need to know about your job, your severance, being let go, hiring new people, being the boss, all those things. Workplace harassment. We cover the aging population of the workplace. That is all under the banner of employment, and we cover it each week here on the show. 1-855-821-5900. That is the number anytime to get a hold of Lior, or help@employmentlawyer.ca. That is the email. We have lots of stuff to get through today, but we always start, Lior, with the week that was. Some things that have been come across your desk are of interest to me and you and everybody else watching.
Yeah, we always talk about matters that came across my desk because there's important lessons to be learned, and this week was no different. I spoke with a lot of people, John, that have found themselves in workplace problems. Sometimes they lost their jobs, other people had harassment issues that they were facing. Some people felt that their employers were not being fair to them or they were owed money, and that's great because I always like to say that whatever the problem is, there is a solution. I can almost guarantee that, no matter what. Now, you may be sitting there thinking, my problem is kind of helpless, there's nothing I could do. Wrong. There's a solution. Call me if you don't know what it is. We can always talk, we can always chat, and just by listening to the show, hopefully you'll learn some of those solutions that are available to you. So workplace rights, very important. And the week that was, let me tell you about a matter that just came across my desk within the last 48 hours. And this matter kind of busts two myths. One with respect to probationary employees and one with respect to short service employees general. So I spoke with a person that was hired just over 2 months ago as a sales manager. And he was hired to do a senior position. And 2 months later, the company came to him and said, you know what, it's not really working out. We're going to have to let you go. And you know what? I think they were right. It probably wasn't working out. They're just not the right fit. They weren't a bad company. He wasn't a bad guy. That just wasn't the right fit. So I think they probably made a sensible decision to part ways. What they said to him is, you've been there for 2 months. You're still under probation. We don't owe you anything, but we're going to be good guys. We're going to give you 1 week's pay. And he called me. He called me because actually someone that he knows saw this show and told me, you got to call Lior. So he called me and he wanted to know what his rights are. He's been there for 2 months. Well, here's the thing, John. First of all, the general rule is that if you're on probation, probation doesn't actually exist unless it's created in an employment agreement. There's no such thing as automatic probation. No, it doesn't happen. Some people think automatically 3-month probation. Nonsense. Your employment agreement has to say that and has to say it specifically. That's number one. Number two, short service employees are treated disproportionately better than longer service employees. So this guy has worked there for 2 months, but guess what, John? Even after 2 months of employment, he was still owed, I assessed him, 3 to 4 months of pay.
Wow.
3 to 4 months of pay.
Twice as long as he worked.
Twice as long as he's worked. And some people may think that's crazy. How can a 2-month employee get 4 months of severance? Well, John, that's how the law operates. The law treats short service employees disproportionately better. So I want us to talk about this, and I want our viewers to understand this, that you may have lost your job shortly after you started working. That does not mean, number one, you're on probation, and number two, it does not mean you don't get severance. So unless you sign an agreement that puts you on probation and allows the company to let you go with no compensation, that's not something that they can do. So he actually thought that a week was probably fair because he's only worked there for 2 months. 3 to 4 months is what he's owed. So if you're there, you lost your job, you're thinking, I'm not owed much, I was there for a few months only. Nonsense, that's wrong, call me.
And is it disproportionate for the fact that, hey, these guys, it might take them just as long to find another job as it is for a man or woman who's let go after 2-3 years of employment?
That's exactly the idea. Just because you worked somewhere for a short period of time doesn't mean it's going to take you less time to find another job. It may, in fact, take you longer, because you would have to explain to the new company why you only lasted for a short period of time with the previous company. That's why you get good severance, very good severance, even as a short service employee. That's why you need to understand that you can't accept less than what you're owed. I bet you, if we asked 9 people or 10 people about this 1 week's pay, 9 would have said, yeah, that's good. It's not good. It's wrong. 3 to 4 months is what he was owed.
EmploymentHourTV.ca is a wonderful resource to find a radio show where we're on all over the place. We've been doing that for over half a decade now. We take a ton of phone calls, and we like to play back some of those phone calls because, quite frankly, we get all kinds of issues when it comes to employment, and the important ones that people should listen to and see is what we like to get to every week. We'll get to a phone call now.
I started a new job about a year ago for a transport company, crane operator. On my third day into the job, my trainer decided while I was trying to pick up a container about 50 feet in the air that he was going to slap me. Instead of reacting, I just walked off the job site, called my manager. The manager didn't do anything about it. They didn't discipline him, nothing. There was no compensation for anything. He didn't even take my claim seriously. I actually didn't find employment right away. It took me about another additional 9 months.
Wow.
Okay.
Wow. Well, obviously this deals with workplace violence issues. So I want to, right off the bat, if someone assaults you, this is what it is. Someone hits you, that's an assault. That could be a criminal matter. So right off the bat, he should consider, he may want to involve the police by all means. But beyond that, as an employment law issue, an employer has to deal with workplace violence. It's in the statute, they have to. So if he goes to his employer and says, this guy hit me, you got to do something about this. You got to put me in a situation where I don't have to feel threatened going to work. And the employer says that's your problem. That's illegal. They can't do that. You have a right to feel safe at work. It applies to harassment, and it certainly applies to violence. So in this situation, if he decides to quit reasonably because he feels unsafe at work, he was assaulted, the company didn't do anything about it, that's not really a resignation, that's a constructive dismissal. He's only resigning because he's been put in this situation, not because he wants to, which means he's going to be owed severance. So the question then becomes, we know he's owed severance. We know the company did something wrong. Well, how much severance does he get? So rather than just tell you, let me take you through the severance pay calculator so that everyone can see exactly how much this person would be owed. So let's take his information, plug it to the severance pay calculator. So he's a crane operator. He's only been there for a very short period of time, a few days. I don't know his age. I picked, let's say he's in his 40s. Well, someone in his situation would be getting somewhere north of 3 months' pay. Now, he's worked there for 3 days, John.
Right.
Okay, north of 3 months' pay. So depending on his compensation, you can obviously assume that's a fair amount of money. So why am I telling you this? Number one, to understand that if you quit because of something that happened at the workplace, because your employer doesn't protect you, doesn't help you, doesn't allow you to continue working, that's not a resignation, that's a constructive dismissal. And also to make the point we made earlier, that short service employees are treated a lot better when it comes to severance. So even after a few days of work, you could be owed a few months severance.
I can't picture out of 1,000 people you ask on the street who wouldn't just walk away and say, oh, 3 days? No, he doesn't get anything. The employer, now they don't have to get anything. It's, call it quits. Not 3 to 4 months.
I agree completely. That's exactly what would happen, but that's why we're here.
Right.
If these things are obvious, if everyone knew these things, we would be wasting our time here.
Exactly.
So yes, that's exactly how it is, so don't ever assume otherwise.
Help@employmentlawyer.ca is the email anytime you want to get a hold of Lior, the firm, or a part of his team as well, 1-855-821-5900. Let's get to another call.
I've been with this company now for almost 4 years. I was made aware recently that I've been put on a performance improvement plan, and I've been on one for 2 months without being made aware of it beforehand. Can you be put on a performance improvement plan without being made aware of it, even if it's an informal one?
The old secret performance improvement plan. Yeah, so
Here's how you improve if we don't tell you.
Yeah, don't worry about it. It's secret. We can't talk to you about that. Yeah. It's ridiculous. I mean, I'm joking around here, but I'm joking around because it's so ludicrous. Well, what is the point? What is the purpose of a performance improvement plan? Is to tell someone, you're not doing a good job. You need to improve your performance. So if you don't know that you're on a performance improvement plan, if you don't know you need to improve your performance, then what's the point? It doesn't do anything. So can you be on a performance improvement plan without knowing it? Absolutely not. It's absurd. Now, beyond that, if the company is going to try to use that at some point to say, well, we put you on a performance improvement plan, you didn't improve, so now we can let you go for cause, nonsense. They won't be able to do that either because that initial performance improvement plan was not legitimate. So they can't use that as grounds for potential termination for cause. So if you've been put on a performance improvement plan, if it's a legitimate one, well, if it's fine, okay. If it's not, if you don't agree with it, say so. Put that in writing, explain why you don't agree with it. You don't want to just accept it. But no, you cannot be put on a secret performance improvement plan where you don't know anything about it.
This is something we reiterate every week, and that is when you're talking with your employer, when you're dealing back and forth, whether it's positive or negative, always write it down. Have a written record of it.
If it's not in writing, it doesn't exist. So any communication with your employer about your employment, about the terms of your employment, about your rights have to be in writing. You do it in writing, you'll never fail. You don't put it in writing, you're going to have problems.
Always check out severancepaycalculator.com as well. You want to find out how much severance you are actually owed, not the one written on the paper, because spoiler alert, as you say, it's almost guaranteed to be inaccurate as well. We'll talk a little more later in the show about Severance Pay Calculator. First of all, I did mention off the top, your rights in the aging workforce. baby boomers are getting up there. They're looking at retiring. They maybe have some nest egg. It's time to call it quits, or maybe they don't want to. That's another issue. Talk about that for a moment.
Well, we used to have something in Ontario called mandatory retirement. That was abolished some 11 or 12 years ago. So employers used to be able to make people retire at the age of 65. That's wrong. That's gone. The laws changed. So right now, employees can work as long as they want. And some employers may not be happy with that. It is what it is.
Right.
So, but the reality is, with an aging workforce, you don't have to read the paper every day to know that we have an aging workforce. Some people may find themselves working at 65, at 70, 75, and they may have some issues. As you get older, there may be some physical limitations. So what we want to talk about is how do employers and employees deal with an aging workforce, especially if there are employees that may not be able to do the job the way they did before.
And we'll get to the first point in that regard is what can employers do with older employees who become less productive?
So an older employee sometimes may, not always of course, but sometimes may become less productive. Now, from an employer standpoint, if the reason for that is someone's age, maybe they're having some aches and pains or other health issues, you have to provide accommodation. You can't penalize them for it. You have to make sure that if there's a medical issue, if you observe that there's a problem, ask about it. Is there a medical condition? Is there something I need to know? Encourage them to provide you some information from a doctor, and then you have to provide accommodation. Maybe help them do their job, give them some other duties, other hours. You can't just ignore it. You can't just say, well, you're not doing the job the way you used to, so you're out of here. You have to understand now, if someone is slacking off, and that's why performance is suffering, well, it's different. Yeah. You can discipline, potentially even let go. But you cannot let someone go. You cannot penalize them because they're slowing down because of age. That's where the duty to accommodate comes in.
The flip side of that is the employee, if he or she finds they're struggling at their job, how do they approach that?
So I always advise employees to be honest with their employer. So if you're now struggling, you have some health issues, whether they're age-related or not, but something is impacting your ability to do the job, first of all, speak to your doctor. Explain that to them and provide some information from the doctor to your employer, explaining what the limitations are. You don't have to explain what the medical condition is, but if you have limitations, you can't lift more than 30 pounds, you can't stand more than 1 hour at a time. Put that in writing, because once you've done that, number one, the employer is going to understand. And number two, once you've done that, it puts an obligation on the employer to now accommodate. So be honest, be forthright, and provide medical information to your employer.
I think the key part of that is get medical backing, right? Because the doctor has final say.
It does. Yeah. If you're just going to your employer and say, I have a bad back, that doesn't automatically trigger an obligation to accommodate. You need to have that from a doctor. Once you have that information from a doctor, the employer has to do its part.
1-855-821-5900 anytime you want to get a hold of Lior or the member of his team. If you got an aging workforce and the employees getting older, they can't keep up, can they be disciplined for that?
So a lot of employers call me and they say, well, I have these employees, they're good guys, but they can't keep up, they're getting up there in age. So as I said before, if they can't keep up because of their age or because of health-related issues that have to do with their age, you can't let them go. You cannot be penalizing them in any way. You have to accommodate. That may mean you may have to tolerate employees whose performance is not the way it was or the way you may want it to. One of the duties to accommodate is to tolerate this performance. Now, you don't have to tolerate employees that don't do anything.
Right.
You still have a right to expect that employees are going to be productive. Yeah, you run a business and that they contribute to that business. But some accommodation does require, or some discomfort, if you will, is required. So you have to provide that accommodation. You can't just say, you're not doing the job, you're out of here. You do that, you're going to find yourself with a human rights violation.
This week we're talking about dealing with an aging work population. If an employee has someone who's getting a little older, maybe they've slowed down, less productive, can they be let go? Can they be terminated? And if so, if you can do it, how do you do it?
Yeah, well, here's the thing, John. No, you cannot let someone go because it's related to age or because it's related to a medical condition tied to age.
Right.
Cannot be let go unless it's to the point that it's so bad now that you cannot provide any accommodation.
Undue hardship.
Undue hardship. Yeah. If accommodating them will be so difficult that it's going to cost you so much money, it's not possible. Maybe the limitations are so strict. But you are expected to accommodate even if it's hard, okay? At some point it becomes too hard. Mm-hmm. So you provide that accommodation. It's only if you reach the point of undue hardship, where it's too difficult to accommodate, then you can let someone go. And I want to make a comment on that. If you are going to let go an older employee, remember, age is one of the factors that go into assessing how much severance.
That was my next question.
You and I
were with the severance,
yeah, we
right?
know.
How do they work that out?
How does that? So, and age is one of the factors. That means that the older the person, the more severance they get. So, if you are going to let go of an older employee, you're going to have to account for that when you calculate severance. They're going to get more severance than a younger employee. So, very important for our viewers to understand. If you lose your job and you're an older employee, you get more severance than a younger employee. So, go to severancepaycalculator.com, whether you're an employer or an employee. Call me or email me if you don't know what your rights are. Again, employer or employee, and we can talk through it.
If you're an older employee and you've been let go and just something's telling you, I don't think it's performance-based. I think I was let go because of my age. We've had a lot of phone calls on the radio show. How do they deal with it?
So obviously, if you're let go because of your age or any way related, even if it was part of the reason, that's illegal. Right. That's a human rights violation. That's probably the most obvious human rights violation. You cannot be let go because of your age. So if something is not sitting right, if you think that that may have been part of the reason, then we need to investigate that further. Let's meet, let's talk, let's understand what happened. Were you the only person let go and everyone else stayed and everyone else is younger than you, or were you part of 20 people let go? If you're the only person let go and they picked you and everyone in the department is 45 and you're 65, well, it's pretty much starting to look like age is a factor. So we need to talk about it, understand it, and decide whether the termination is legal or not. And of course, also assess the amount of severance that you're owed, because if you have a company that lets you go because of your age, I bet you they'll also try to lowball you big time on the severance.
We mentioned Severance Pay Calculator. We'll get to that after a short break, and dealing with the independent contractor as well. Lots more Employment Hour 30 is on the way. Stick around.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
And back with more Employment Hour in 30. If you haven't checked it out already, over 500,000 people now have. We're going to talk about Severance Pay Calculator. You can find it at severancepaycalculator.com. Give me some business. What's it about?
Severancepaycalculator.com, a tool that anyone can use. And if you haven't used it, do yourself a favor. I don't know what you're waiting for. Go to severancepaycalculator.com right now to find out what you are owed if you lost your job. You don't have to actually have lost your job. It's important information to have, even if you're secure in your job, because you never know. And you want to know what that information is. You want to have that information available. And that way, if you do lose your job, if you are staring at that severance offer, you're not going to be surprised. You go to severancepaycalculator.com, you answer 3 simple questions: your age, your position, the length of your employment, and you find out what you're owed. You don't have to put in your name, you don't have to put in the company's name, it's anonymous, it's free, it's simple to use, and it's the easiest way I could ever think of to allow everyone to find out that important piece of information. In the past, you'd have to call me or another employment lawyer. You don't need to now. You can do that at midnight or on the weekend when no one's available to pick up a phone. severancepaycalculator.com.
There's a contact button at the bottom. It's absolutely free, so you can give it a try on your desktop, your phone, your tablet. It doesn't matter. I want to run through a scenario and get you to expand on this. And you can try to guess how much severance they should be getting, because I guarantee you,
I get it wrong.
It's going to be wrong. Sherry was just restructured out of her senior management job at the bank. She's 57. After 18 years, she was earning $150,000 in salary. Her employer offered her 36 weeks of severance. They said that because they're federally regulated. They actually owe her much less than that. But they wanted to be nice, wanted to be generous. Should she accept that generosity?
Yeah, very generous. How grateful she should be. So before we even talk about numbers here, let's talk about the whole federal thing.
Right.
Federal employees, provincial employees, they get the same amount of severance. Let's be very clear. You don't get less severance because you're working for a federally regulated employer. Absolutely not. It's the same based on age, position, length of employment. So let's plug that into the Severance Pay Calculator. Again, severancepaycalculator.com so that you can see how it works. So she's in a senior position, she's been there for 18 years, she's 57 years old, making $150,000. She was offered 36 weeks, that's about 8 months or so. Well, she's owed 18 to 24 months pay. 18 to 24 months, for her, that's over $120,000, close to $200,000 extra that she's owed. Now, why did I pick this example? Because this is some matter that came across my desk, was in my office just days ago, so I wanted to bring this up here. So this person actually was offered $150,000 less than what they're owed. And there's nothing unique about that, John. This is not one of those crazy once-in-a-lifetime situations. I see this all the time. Now, you may not be owed $150,000, but you may be owed $10,000 or $20,000 or $50,000. So go to severancepaycalculator.com. Your employer may think that it's being generous. Let's give them the benefit of the doubt. But it's not about what your employer thinks. It's about what the law says. The law decides what you're owed. Yeah. So go to severancepaycalculator.com.
And in Sherry's case or any other case, it's not just $150,000 in pay. It's benefits. It's possible, bonuses, car allowance. All that stuff,
it's
right?
all of that stuff. You have to get paid for all your components of your compensation. So your employer's not going to forget about your salary, but you probably have other components of compensation. So all those have to be included. And if they're not included, that's a wrongful dismissal.
EmploymentHourTV.ca is where you want to go to find out where you can catch our radio show, our hour-long radio show weekly, all over the map. So check out that show when you can. In the meantime, we'll play a phone call from the show because we like to get a ton of feedback on these.
I'm a veterinarian working in a clinic, and I'm considered self-employed. So I charge my employer 13% on every invoice based on hourly rate. And I was wondering if I'm considered an employee there, if I'm actually not working anywhere else. I work about 38 hours a week.
Big time employee.
Yes, it's such an obvious situation, and one that I see often. I see often in many industries, but certainly when it comes to doctors' offices, whichever doctor, we see that very, very, very often. So if she works for 38 hours, if she has a steady job, she's been there for a while, she is an employee. Yep. It doesn't matter how you structure your business. It doesn't matter how you pay your taxes. It doesn't matter if you invoice the company. The law is smarter than that, right? Substance over form. If you look like an employee and you act like an employee, you are an employee. So she is owed compensation. She needs to be treated as an employee. She'd have all the entitlements of an employee, whether it's overtime, hours of work, vacation, severance when the time comes to it. So there's no way someone works somewhere for 38 hours a week and is not an employee. It's just not going to happen.
Their only job? Obviously.
Nonsense. It can't be. It's impossible because, again, if that was possible, then everyone can be an independent contractor. I have 50 people in my office all working full-time. What's stopping me from calling them independent contractors
to pay severance.
and me saving a whack of money that way? Can't do that. That's why the law says if you look like an employee and act like one, you're an employee.
Help at employmentlawyer.ca is the email, or the phone call is 1-855-821-5900. We'll talk about temporary layoffs and get to more of your phone calls after a short break here on Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. We take a ton of phone calls on the radio show, employmenthourtv.ca. You want to find a radio station where you can hear that hour-long show, which is pretty soon will be 6-7 years doing that. So we've had to talk to a ton of people in that amount of time, and some really interesting calls and scenarios and trouble spots that people are in. So I want to get to another phone call. Lior, I'll get you to comment on this one as well.
My wife, she was working for a company as a welder for 16 years, and in November, there was a temporary layoff of her and about 17 of her work colleagues, and she was given a letter saying that if she was not called back within 35 weeks of the original layoff, that she would then receive her severance. And I'm just curious if that 35 weeks is a reasonable number or if that's not reasonable. She was there for 16 years.
The old temporary layoff.
The old temporary layoff. So that's an easy one, John. And it's an easy one because an employer does not have a right to lay off temporarily. What I mean by that is if your employer lays you off temporarily, that is in fact a termination, which means you can get your severance now. You don't have to wait 6 weeks, 12 weeks, or 35 weeks, okay? Now, there's a lot of misconception, a lot of confusion about it. So hopefully if you're watching us right now, you're no longer confused because I just told you that a temporary layoff is a termination in almost every case. So if that happened to her in this particular situation, no, she doesn't have to wait 35 weeks or 25 or any other period of time. She can if she wants to, but she can treat her employment as being terminated now, immediately, today.
I'm waiting for the but.
And get severance. Yeah. Now, the but is this. If she does decide to wait, if she does wait and then eventually goes back to work 35 weeks later, by doing that, she's given them the right to do it again. That's the problem, because I just told you that an employer cannot lay you off temporarily, but they are allowed to do it if you let them do it in the past. So you don't want to open that door, because if you open the door a crack, the employer can kick it right in. And at that point, you may have a job for a few months, you get laid off for a few months, and round and round you go. It could go on forever. That's not a way to work, that's not a way to live, that's not fair, that's not proper. So if your employer is going to start messing, so to speak, with the terms of your employment by putting you on a layoff, you should treat that as a termination. But before you do, of course, before you off and quit and say severance, call me. Let's talk about that. But generally, John, a temporary layoff is a termination.
1-855-821-5900 is the number. help@employmentlawyer.ca for email as well. Another resource for you is terminationquestions.com. You can simply go there during the show, after the show, ask questions, and Lior, a member of his team, we'll get back to you with an answer. I'll get to one here. It says, love the show. That's off the top. Throw that in. There you go. I've been with the company for 12 years. We've just been sold to another company. The new company is demanding that I sign a new employment agreement. Do I have to sign it? If I refuse, can they legally fire me?
That's a great question, and a lot of people get very worried, as they should be, frankly, when a sale of a business happens. So generally speaking, a company that sells the business, if you start working with a new company, they inherit your service, which is important, because if the new company lets you go a week, a month, a year later, you get your severance based on your full service. You don't lose your service. But, and there's an important but here, the new company is allowed to enter into an employment agreement saying, no, we are not going to inherit your service. We're not going to take on that liability. So oftentimes that's what happens. So if you are about to accept a job with the buyer, the business is sold, you've been offered a job with the buyer, you want to accept the job, that agreement, if they ask you to sign one, is an extremely important one.
You bet.
You want to be careful. You want to make sure that there's nothing in there that says we're not going to accept your service. I would much rather an employee that starts a job with the buyer do it on a handshake, or do it without a handshake. Just start working. Okay, less is more, absolutely. So can they decide not to hire you if you don't sign? Yes. But if you have a good reason as to why you're not signing, because you're giving away your rights, then you're going to get your full severance. So you don't have to be worried about, oh my God, I'm going to be left on the street with nothing. It's not going to happen. Right. I would much rather you leave with severance than give away that severance and be let go a month later, and then you realize, holy cow, $50,000 I just lost because of that agreement that I signed. Happens all the time. So with the sale of a business, let's be very clear on this. The new company, if you start working with a new company, they inherit that service unless you sign an employment agreement that says otherwise. So with that situation or any situation, John, when you're asked to sign an employment agreement, whether you're working for a company or about to take on a new job, you want to be very careful. You don't want to give away your rights. Oftentimes, as relates to severance, employers are getting smarter, more sophisticated. They're entering into agreements that at some point can cost you tens and tens of thousands of dollars. So you want to be very careful about that. If you're not sure what an agreement says, what it does, or if you should be worried about it, let me see it, call me, email it to me, fax it to me, let me review it and tell you what it means.
You can imagine someone who's coming from a 30-year job. They don't sign it. or it's assumed they do sign it, and a month later they're gone and they get a couple weeks severance.
I have seen that happen because people didn't pay attention to what they were signing. They didn't know they should be concerned about. Don't let that happen to you. It's so important to be careful of what you sign. And again, if you think it's okay but you're not sure, let me see it for peace of mind.
Yeah.
It's worth the phone call.
Another good weekend. We'll take it from there. You want to contact Lior, there's a bunch of different ways. Of course, terminationquestions.com is one. There's email as well, help@employmentlawyer.ca. Good old phone call, 1-855-821-5900. And there's employmenthourtv.ca as well. And always check it out, if only for fun, for giggles, severancepaycalculator.com.
It's fun at parties, by the way.
Well, it is fun at parties for about 15, 20 seconds, and then you move on to better things. But it will give you information you need. Severancepaycalculator.com. Do not go anywhere or sign anything until you go there. Till next time, Employment Hour in 30. Thanks.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.